My name's Professor Christine Parker from the Melbourne Law School and the ARC Centre of Excellence for Automated Decision Making and Society, which is quite a mouthful, but we like to call it the ADM+S. And I'd like to welcome you all here this evening for this event on AI and the courts and tribunals. Before I make a few introductory remarks, I want to acknowledge that we are here on the unceded land of the Wurundjeri people. And of course, here at the university, we are committed to the ongoing work of justice and reconciliation. I know I've been in this building a few times, and maybe Jeannie will say some words later where it's also been pointed out that this is the site of the old women's hospital as well. And I might leave it to Jeannie to have something to say about that. So this event this evening is co-hosted by the Victorian Law Reform Commission, thank you, and with Melbourne Law School, the ARC Centre for Automated Decision Making and Society, and the Centre for Artificial Intelligence and Digital Ethics. And the occasion is the issues paper that the Victorian Law Reform Commission have put out on the use of AI in courts and tribunals, and the fact that you're all here means that we're hoping everybody puts in a submission afterwards, and we're aiming to get some good discussion going around that. Before I introduce Jeannie, who's going to host the panel, I just want to point out that we are recording this session, so you'll see there is a camera up the back there, and we will be recording the panel discussion, and we'll be making it available afterwards on the ADM+S YouTube channel. We will record the Q&A part where the audience speak, but we won't be publishing that part of the video, but the VLRC, I know, would like to have that available to them to help them in their deliberations. So I just wanted to let you all know about that. Okay, I'm going to hand over to the marvellous Professor Jeannie Paterson, my colleague, Professor of Law at Melbourne Law School and Director for CAIDE here, who is an expert on all things AI, law and digital ethics. And Jeannie's going to be hosting our panel discussion tonight and introducing the panellists.
Thanks. Thank you so much, Christine, the marvellous Christine, and welcome everybody here. I'll just say a couple of words about the building. This building now houses the Faculty of Engineering and Information Technology, and predominantly has computer scientists in the building, as well as some startups and other organisations. We have a childcare centre, and we also have graduate accommodation, which is just behind you. If you had a chance, you'll have seen downstairs we have a science gallery, which is a gallery of science and art driven by the preferences of a group of young people who consult in what sort of things should be in the science gallery. And in the very middle, we have the Oculus, and the Oculus is built to remember the origins of this building as a site of birthing. That's a thing of great joy, and some of you here today would have been born here. It's also a moment of sorrow, and we like to remember that as well, because this is the place where many Indigenous women had their babies stolen from them under a previous policy. So we also think about the joy and the sorrow that happened in this place, and we do ask people, if they walk through that central area, the Oculus, to think about the birthing history of this beautiful site. Now, what we're going to do today is we've got a lovely panel of experts who's going to talk to us. I'm going to introduce them a bit later. First of all, though, we're going to hear a little bit about the reason we're here, which is the wonderful report that's been prepared by the Victorian Law Reform Commission on the use of AI in the law. And we're lucky enough to have the Honourable Jennifer Coate, AO, to speak to us. Jennifer Coate AO was appointed as a commissioner to the Victorian Law Reform Commission in June 2020 and is acting chair of the commission while the chair is doing other important business for the good of Australia. And she's held a number of judicial appointments, including Judge of the County Court of Victoria, State Coroner of Victoria, the inaugural President of the Children's Court of Victoria, Senior Magistrate at the Children's Court of Victoria, Magistrate and Deputy Chief Magistrate at the Magistrates Court of Victoria. And she was appointed a Judge of the Federal Court of Australia and thereafter served as a Commissioner on the Royal Commission to Institutional Responses to Child Sexual Abuse. And I think is well placed to be leading this project, because one of the things that we do know about automated decision making is without proper guardrails, the people most affected by the excesses of that process are the people who are most vulnerable in society. So I'm now going to invite Jennifer Coate to speak to us. I'm going to give you the microphone.
Thank you. Imperceptibly, we hand the microphone from one person to another. So I too wish to acknowledge the traditional owners of the land upon which we all gather this evening and pay my respects to elders past and present, and particular respect extended to any Aboriginal people joining us this evening. My first very pleasant task is to say thank you to the Melbourne Law School and the other organisations that you saw up there on the slide, whose full names you saw and whose acronyms I can give you, but I'm sure I don't need to. We had a fantastic and very willing response and participation in the wake of our issues paper coming out from the various organisations represented by our hosts and indeed our panel members. And indeed, I extend that thanks to all of you for the interest that you've shown by attending this evening. So for those of you who've had the opportunity to have a look at the issues paper, you'll appreciate the breadth and depth of the issues that we at the Law Reform Commission are engaged in. Suffice to say that the rapid evolution and scale of applications of artificial intelligence across society generally brings both extraordinary opportunities for courts and tribunals and the justice system more generally, but with those opportunities, of course, come risks and necessary cautions. So I'll come to that in just a moment, but let me introduce to you, for those of you who haven't yet had the opportunity to look at our issues paper, those very wordy terms of reference, which I don't expect you to read, but they will be available in the slides. In May of this year, the State Attorney General gave the Law Reform Commission these terms of reference and asked the Law Reform Commission, in that normal way in which Law Reform Commission references are given, to make recommendations, and in particular to make recommendations about any legislative opportunities for reform and principles that may take some form ultimately in terms of where we land at the Law Reform Commission, principles for the arrival in the way in which AI at the moment is permeating the legal system, and principles that can be used to assess the suitability of artificial intelligence use in Victoria's courts and tribunals. Many of you would know that at this stage there's currently no AI-specific legislation, indeed in the nation, and certainly not in Victoria. But there are now some federal voluntary guardrails for organisations that are supporting the safe use of artificial intelligence, and indeed the federal government has proposed some mandatory guardrails for high-risk forms of artificial intelligence. So we have, of course, as has been pointed out recently, the operation of courts and tribunals are a highly regulated environment in terms of all of the pieces of legislation that the court is both controlled and guided by, as well as, of course, the powers, both statutory and otherwise, given to courts. But the question before us at the Law Reform Commission in the course of this work is whether or not there are potential gaps in terms of legislative gaps, framework gaps, or indeed whether there are principles or large-scale pieces of framework that we may require for the purposes of guiding our institutions into this somewhat unknown territory. So let me just introduce you to where we have got to in the issues paper in terms of the development of our thinking. And we bear in mind we're right at the start at the moment of our consultation period. So we're not making any commitments. We're simply in the issues paper saying here's some of the preliminary work that's been done to help shape those of you, and we hope that will be many of you, make your submissions back to the Commission and potentially participate also in consultations. So we have identified 8 possible principles to support the safe use of AI in Victoria's courts and tribunals. And let me just quickly take them through you because I don't want to take up the time that will be used by a fantastic expert panel to take a deeper dive into these principles. So these principles, I should say, have been distilled by the team, both looking nationally at those courts and tribunals that have already put some guidelines in place, where the national discussion is going, but indeed where the international discussion is going also. So the first of those principles, and they're not in any particular order, but I think it's fairly uncontroversial to say that a pretty fundamental principle for the operation of courts and tribunals and the justice system is that the introduction of any AI system should be impartial, fair, equitable, and understand and be non-discriminatory and understand the potential risks of bias. The next one, accountability and independence. Courts and tribunals must maintain their independence consistent with the requirements of the separation of powers and must be accountable for their decision making. I think, again, fairly uncontroversial. I add in there under that heading that court users also should be accountable for their own use of artificial intelligence. Next, on the list of principles that appear in the issues paper are transparency and open justice. So I think, again, there's a fairly widespread view amongst those jurisdictions that have already started turning their minds to these principles in a more detailed way, say that courts, tribunals and court users should be transparent about the use of AI. How that ultimately emerges remains to be seen, but a number of the courts that have issued guidelines to date have paid particular attention to the court users and the courts themselves, making clear when AI is being used. Next is contestability and procedural fairness. So what in simple terms this principle addresses is people whose rights or interests are affected by the use or output of artificial intelligence should be able to challenge adverse outcomes or uses. Next is privacy and data security, one of those principles that has obviously a wide range of applicability, but a very particular meaning inside courts and tribunals where AI systems in use need to be extremely careful to ensure that Victorians' privacy and personal information is appropriately protected. Access to justice is the next principle that emerges from our issues paper, and again, it's one of those principles that has the capacity to be to provide a considerable boost to access to justice for court users, but it carries a huge range of risks on the other side of the ledger. So the principle that some of the courts have adopted in certainly in the international space have been that courts and tribunals should support access to justice and minimise existing barriers or inequalities. And the next principle on the list is efficiency. The court's use of AI systems should demonstrably contribute to the efficiency of the justice system. And the final principle in the list of 8 is that any systems that the courts and tribunals are going to use should maintain human oversight and monitoring. Human oversight should be retained to address the risks relating to those areas like bias and reliability and accuracy, and also privacy and security of the data. So I'm going to stop there. I'll come back just at the end and put up a slide that tells you how to make submissions. Our final date for written submissions is the 12th of December. Our final report is due back to the Attorney-General on the 31st of October next year, hopefully bearing no relationship to Halloween being on that night, spooking people. Other than that, just to say that, of course, it's fantastic and very uplifting for us to see the level of interest right across this area. And we are interested in your views. We're going to, for the purposes of the panel discussion, we're going to leave those principles just up on the screen, so as both our panel are talking and hopefully we get some interaction from those of you sitting in the room, that these set of principles anchor your thoughts.
Thank you.
Thanks, Jeannie.
So we have a fantastic panel to talk about some of the issues that arise from AI and automated processes in the legal system, in the courts. I'm going to spend a bit of time introducing our panel because they're so impressive. And then I'm going to ask the panel some questions, and then it'll be over to you, the audience, to ask the panel some questions, and we will leave time for you to talk. But we thought that it's good for the panel to kind of walk through the issues that we might be concerned about. So I'm going to start with Kim on your left. So Kim Weatherall is a Professor of Law at the University of Sydney, focusing on the regulation of technology and intellectual property law. And Kim is also a Chief Investigator with the ARC Centre of Excellence for Automated Decision Making that Christine spoke about earlier. And she leads projects on the regulation of AI and automated decision making and the use of generative AI-based agents for policy making. Kim is, I've just lost my page 2. Kim is a fellow of the Gradient Institute. No, I'm going through it. A research institute developing ethical AI, and a member of the Commonwealth Government's 2024 Temporary AI Expert Group, with whom I have had many interesting conversations. Next, we have Professor Julian Webb. Julian joined Melbourne Law School in 2014 and teaches in the areas of legal ethics, civil procedure and regulatory theory. Julian has led the Melbourne Network Society Institute project on regulating automated legal advice technologies and coordinated the Law and Legal Services in-book paper to the Australian Council of Learned Academics report to the federal government, which was the effective and ethical development of artificial intelligence. His recent paper, Legal Technology, The Great Disruption, was shortlisted in the Australian Legal Research Awards in 2023. And a fun fact is that the Melbourne Network Society Institute was the predecessor of the Centre for AI and Digital Ethics. They morphed into each other. Emma Poole, next is Claire Bennett. Claire is a decision maker with the Victorian Civil and Administrative Tribunal, VCAT, and a chartered professional engineer with experience in matters involving land, water, energy, environment and resources. She is an expert member who resolves disputes and makes decisions in the Planning and Environmental Division of VCAT. And Claire has an interest, and I would add expertise, in the nexus of artificial intelligence, engineering and law. And she has previously presented on the use of artificial intelligence in case management and legal analytics at the 2023 Victorian Law Week series of events. Claire is currently the co-chair of the VCAT AI Committee and a member of the Court Services Victoria AI Working Group. So I'm very pleased to have you here and sharing your insights with us. Thanks, Claire. And right at the end, Emma Poole. Emma Poole is a barrister at the Victorian Bar whose practice encompasses advice and appearance work in commercial, common law and administrative matters. She formerly worked for the Supreme Court of Victoria and the World Intellectual Property Organisation in Geneva. Emma has an interest in the intersection between technology and law, including AI, cybersecurity, intellectual property and the use of technology in court. And she is currently chair of both the Bar's Innovation and Technology Committee and the Law Council's Australia's Legal Technology Committee, and I'm going to say a graduate of Melbourne Law School. So thank you everybody for being here, all of you for being here, and you will have to share microphone. Oh, you've got some clip-ons. Oh, wonderful.
Julian.
Impressive. Okay, so we're going to start, as I said, with a conversation between the panellists and myself about the issues involving AI in the courts, and then we'll move to a conversation with you. And we're not following precisely the report, but most of the issues that we touch on are discussed in the report. And the report has a really comprehensive bibliography with lots of things that you can deep dive into if you're interested. In fact, it's probably the most up-to-date AI and law bibliography you're going to find anywhere at the moment. So thank you to the report writers. Okay, so let's start. We thought it would be a good idea to start with Kim. Kim, can you talk to us about what we mean when we're talking about AI in the courts? What technology are we talking about?
Quite a few. And I think I'm really glad that you're starting there, because I think it's really important that we do break down this term artificial intelligence and understand that there's a whole lot of technologies that come under that heading. I mean, in short, it's not just ChatGPT, even if that's what gets most of the attention these days. It's really important to kind of understand the different types of technology and what they do, and break down how the different types of technology intersect with legal questions. So, you might recall, as back in the deep dark ages of November 2022, we were talking about AI. We were talking about a different kind of AI from what we tend to focus on today. So these days we call it old-fashioned AI or narrow AI, but we were talking about a range of systems, some of them with quite a lot of hard-coded knowledge in them, like expert systems that would take you through a decision-making process in a way that a human being had decided. But a lot of the attention pre-2022 was on systems of machine learning, where effectively we gave machines a whole lot of data and had them identify patterns and links in that data. And so we were looking for patterns, probably patterns that maybe human beings wouldn't have identified in some of the data. Now, those sorts of technologies had plenty of issues that we still need to be thinking about today, because narrow AI is still very common today. This sort of machine learning that looks for patterns is exceedingly important. So, to give an example, some of the controversies that arose early on were around things like using machine learning to try and identify, say, the risks of someone reoffending, so recidivism prediction. And we look across all of the data about people who have been involved in cases or might have reoffended and try to make predictions about whether someone was likely to reoffend. And I mean, there are many, many issues there. You will have heard of controversies like Compass, the problems of bias that emerge quite rapidly when these technologies were used, the problems of data, flaws in the data, gaps in the data, problems in the data, biases in the data. And also from a legal perspective, the fact that even where links might be identified in that kind of system that would be real, they wouldn't necessarily be the ones that we would be looking for as lawyers, because the facts that are relevant to lawyers to make a decision about someone and whether they should be in jail or not are not necessarily, the legally relevant facts are not necessarily the same as, legal causation is not the same as factual causation, I suppose is what I'm trying to get to. So that's narrow AI, and we do need to keep that top of mind as we think about how AI might be used in the courts. And then, of course, in 2022, we got hit with this new thing called generative AI, or the large language models. And they operate a bit differently. They're also predictive, but in a way what they're predicting is the next word or the next token or the next image if it's an image generator. So these are very sophisticated, probabilistic pattern matching, but they're trying to predict the next word if it's a large language model. And they train over vast amounts of data to try and learn how to answer our questions. Now, I say, and we often talk in these technologies about the fact that they're involved in next token prediction or next word prediction, but it is important to get a little below the surface in that, because it's not just the next most likely word as a matter of some sort of objective reality. Because these systems have been trained by a reinforcement learning, initially, often with human feedback. Right? So what they were learning to do was to give the answer that would get them positive feedback from human beings. So it's not just that they're predicting the next word, so therefore they're not necessarily about finding the truth or finding facts, but they're also trying to predict the next word that we want. And the more we train them, with fine tuning and further training, the more they are learning to predict the words that we want and that will get positive feedback from us. So all of this is a little bit divorced from reality, facts. They're not anchored in facts, they're not anchored in morals, and they're certainly not anchored really in reality. And then if you go a step further, you'll understand that a lot of the time now we're talking about, you hear all the time about ever more advanced models, right? And we're training on more and more data. And you'll hear, if you listen to a lot of the hype in this field, that the more and more data we train on, the more intelligence these things create or generate, the more things they can do, the more capabilities they have. And I think the important thing to appreciate, having spent a lot of time over the last few days talking to people who work on those very large models, is there is an awful lot, firstly there's an awful lot of that we don't understand about how they work and can't possibly understand about how they work, which has legal implications. But also there's a lot of disagreement about how they work and what they're doing. And so you'll read that there's some paper that says that they've developed reasoning capacities. And then a week later you will quite literally read a paper that says, actually we retested it and we're not sure at all that it's capable of reasoning. Actually, if you test it slightly differently, although apparent reasoning breaks down. These models are fragile in ways that we don't necessarily understand. So I suppose the point is, we do need to think as we respond to the consultation paper, as we think about how we might want to use AI, it's not just how do you want to use AI, but what sort of AI, what do we know about it, how much can we understand it, how appropriate is this type of AI for this type of task.
Thank you. Thanks so much, Kim. Now I'm going to turn to Emma. Emma, we talked about different kinds of AI. There's also different kinds of functions we might use AI for in the judicial system. The topic is AI in courts, but there's lots of different things that happen in courts. Can you talk to us a little bit about the different uses of AI perhaps in the courts and the different functions we might be talking about?
Sure. For me, any court or tribunal fundamentally has three thematic groups. And I don't think it's going to come as a shock to anybody, but fundamentally the operation of the courts has at its peak the judicial function. Everything in a court or tribunal is designed around achieving the judicial function. In support of that, there you go. How's that? Oh, reverb. Yeah, so everything in a court is structured with the judicial function at the top. For me, the next section is the registry, and then you have the administrative section, the administrative functions of the court. And for me, this distinction is critical because the really important thing in a court system is that everything has to happen in compliance with the authorising environment. So for whatever function you're talking about, you have to know in a judicial sense where the jurisdiction lies, what powers can be exercised by the decision maker, what discretion can be exercised and according to what criteria that discretion has to be exercised. In the registry, for me, the registry is distinct from the administrative function because the administrative function tends to be operated in Victoria under Court Services Victoria Act or the Public Service Administration Acts or the various acts that apply to security or facilities or HR and those kind of functional administrative aspects of the court. But the registry is a really interesting other aspect because it is the intersection point between the public and the court. It is the place where all the evidence, all the pleadings, all the material that will be before the decision maker, the judge or tribunal member will be put through. And the interesting thing about the registry is it's an incredibly constrained environment legally. There's almost no discretion in a registry as to what can be filed or can't be, and if there is going to be a discretion exercise, it's going to be by a judicial officer. And in Victoria, we also have an interesting quirk, particularly referable to civil actions, and that's the Civil Procedure Act. I'm a total procedure geek, and I apologise to absolutely nobody for this, but one of the reasons I chose to practice in Victoria was because the Civil Procedure Act 2010 is the purest expression of what they call the rules reforms out of the UK. And it embeds certain critical principles, but the really important one is kind of the overarching purpose, and everything within the court system, or the court, all participants, all the legal practitioners, have to all work together to try and achieve the just, timely, cost-effective and efficient to justice. And there are obligations that flow under that. So the court itself has an obligation to do things efficiently. So things around emerging technologies, so as we look at these principles, efficiency is a core principle. And the Civil Procedure Act embeds that as a requirement on the court. Literally, there is a cause of action, presumably there's a cause of action, I don't think anybody's tried it, but to require a court to exercise it, it's one of the most successful things I plonk in pretty much every submission I make on something to the Supreme Court, is reiterating the importance of the court having to embody the overarching purpose. Additionally, I think this is the interesting point that the consultation paper addresses really neatly, and I think will be raised a lot, is where there are existing requirements and obligations which will have effect in in relation to AI or any emerging technology. And one of the interesting principles has been in recent years how many pieces of legislation, both primary or secondary, have as an embedded aim being technology neutral. So they're both human-centred and they're designed according to various principles, but technology neutrality is a core foundation principle. So for me, one of the interesting things around, we hear about submissions being drafted or a pleading being drafted using ChatGPT, for example. There's a overarching obligation in Section 19 of the Civil Procedure Act which requires a proper basis for any claim. Now, it'd be very difficult to say that something that has been generated by generative AI could establish a proper basis. And similarly, you think of the duty of confidentiality that all legal practitioners have in relation to maintaining privacy and data security, but also the confidentiality of their clients' information. So uploading material into one of those commonly available, or even, to be honest, the bespoke tools that we're all being encouraged to spend large amounts of money on at the moment. So for me, that's I will now stop talking because I could talk about this.
So I'm going to grab that. Emma's clearly psychic because I actually was thinking how interesting you were, not that you are going over your allocated time limit, because I would have come and no. Thank you, Emma. So thank you, because I think the reminder, Kim's reminded us that we're talking about a number of technologies. You've reminded us that we're talking about a number of different processes, which actually are already governed by quite specific and demanding rules. So now we're going to move to Claire, who's our decision maker, to talk about the use of AI within decision making and for decision makers. Thank you.
Thanks everyone. I think the starting point perfectly comes off Emma's discussion about the legislation that already exists about the requirements for everyone who's interacting with the court and what their duty to the court is and what their requirements are. So as a true engineer and scientist, I'm going to come at this from quite a dichotomous key approach of the different kinds of parties that are potentially going to use AI, and then the risks and opportunities for those. So if we take the step that Emma started with of the different kinds of functions within a court, so we start with decision makers and judges, and then the parties that present before them, so barristers and solicitors, the professional parties that present before them, and also the non-professionals, so the self-represented litigants. We also then come down into the people that may appear on behalf of those parties, so experts who may represent information to the court and their responsibilities. And then there's the staff within the court, the registry and the like. And within that, each one of those elements have different types of AI that they may choose to employ, or there's different opportunities and risks associated with each of those users. Each one of those is governed by their own individual legislation, but the interesting thing about self-represented litigants, who we have a lot of at VCAT, is that they may not even be aware of the legislation that they're appearing in relation to, let alone the overarching governing legislation that really controls how they should be appearing in court and what they should be doing and their responsibilities to the court or the tribunal. So that's an interesting distinction, I suppose, between professionals who are operating in the court space and non-professionals who are operating in the court space. And to me, that creates an interesting point of differentiation where we might have different guidelines for those different people, or there may be a more specific requirement to have a guideline in place for non-professionals who may appear at courts and tribunals. so that we can lay out the requirements for them more specifically. We already have a lot of those requirements laid out in practice notes, for example, for experts who appear before the tribunal in the courts, and we already have a lot of guidance in relation to how people appear at courts and tribunals. I think the interesting point that you move on to next is decision makers and how they may employ AI. And I say may very distinctly because it's not to my knowledge anything in Australia that is guiding how decision makers may do that. There's a Supreme Court guideline for litigants, and it does reference potential, leaves it open, I would say, for decision makers to use AI. The interesting thing that I think about that is when that decision maker may use AI, or the consideration of it to be more conservative. Before a hearing, the potential use of AI and the opportunities for AI maybe have different risk profiles to after a hearing. If a decision maker is using AI for case management, or for listings assistance, or for summarising cases that may be relevant to their matter, that has a different risk profile and cost, risk, opportunity cost, to using AI after a hearing and using it for summarising submissions or expert evidence, in which case the risk is far, far higher. And there is a lot of consideration at the moment about whether that's appropriate in any form. And that's why the conservative approach that's taken at the moment is that no one is using AI in a decision-making capacity. So that's the context that I see and the outlines of how we can categorise those different uses, I suppose.
Thanks so much. And we're going to come back to this question of who's using what in a minute, but I think we just need, at this point it's appropriate to talk to Julian, because you've heard different kinds of technology maybe described as AI, expert systems, narrow AI, predictive analytics, generative AI, text to voice, voice to text. We've heard about the different processes in the court where we may intervene with AI and the demand that sometimes efficiency will be benefited by the use of it. We've heard about different participants in the court system, from unrepresented litigants through to barristers, solicitors and decision makers making use of AI, and the point that we can't clump those all together. There's a different risk profile from where and how it's used, and different values, not just efficiency but also access to justice. We have rules, Emma's told us, we've already got rules that govern much of this process, but we've also heard that perhaps some people don't know about those rules. Sometimes the role of regulation is to make things clear. So now we're going to turn to our regulatory theorist and ask him, Julian, what does regulation even mean in this space?
I think there's two very specific dimensions of this that I want to highlight. A lot of the report talks about the regulation of AI and how it's used or could potentially be used in the public dispute resolution space. And it's very much about the use of AI in a public space, in a public dispute resolution setting. We're not interested here about private dispute resolution systems, even though those are areas where a lot of the initial work on using technology has actually been done. And part of the reason this area is so important and why we have these principles that we do is because there are certain values and principles we say distinguish public dispute resolution from private dispute resolution. And the question is, how do we best translate that into regulation? There's also a question that I would frame slightly differently from regulation per se, which is the question of governance. And we're kind of getting a little bit more into bigger dispute system design and monitoring questions. So how do we expect the court system as a whole particularly once it starts to adopt some of these sorts of tools to monitor, manage, be accountable for its use of these technologies. And these governance questions, I think, are really, really big, complicated questions. Historically, we'd say, courts traditionally were a little bit like little fiefdoms. I'm not saying we're there now, but that's kind of where we come from within the common law tradition. Not been a lot of formalised structured governance around them. We're not entirely there now, but there are still elements of that fiefdom tradition remaining, and some of that is important because, as we've heard, this idea of judicial independence is a critical kind of value that drives a lot of what we expect from the system. It may be very important in terms of continuing trust in the system. And that creates, at the very least, some tensions, regulatory tensions, with other issues like accountability and managerial style control, particularly when you have, as we do in Victoria, have a very judge-centred system of court management, where one might reasonably expect that some of those judicial values instinctively may well drive perceptions of how the system ought to develop, perhaps more than some of our others. Now, in that context, I think the move to a principles-based framework of regulation, which this issue paper is suggesting, is an incredibly sensible idea. It keeps the regulation within the bounds of what courts do. It keeps it under the control of predominantly of court-based institutions. It potentially does a lot to protect courts as self-regulating institutions in a way that heavy external regulation might not do. There are lots of issues around heavy external regulation of court institutions. So in terms of the form of regulation, there are some big choices that are being made here in talking about a principles-based model. I think there are some other big governance challenges, however, which aren't so well addressed in the issues paper as it stands. And I say this sympathetically rather than simply critically, because I think the governance piece is, as I said, difficult and complicated, because governance also turns on the allocation of scarce resources for the governance function. And courts globally are struggling to get resources. We've seen huge issues of this around the court estate and the, some would argue, the virtual collapse of some aspects of the justice system in England and Wales currently. And I think what quite a lot of the court governance literature acknowledges is that there's a complex relationship between resourcing, the perhaps increasing corporatisation of court administration and government, and the potential and risk of deepening institutional relationships with the executive, parliament and other political actors. So how we deal with this as a resourcing problem has significant practical and policy implications. The extent of stakeholder involvement in court governance is another, I think, highly moot and important question. And again, I think there may be some interesting differences and tensions perhaps in the ways in which judicial officers and others might weigh underlying interests and values in interpreting principles. So that can certainly create tensions within the organisation. We may want to ask whether our substantive principles are actually robust enough when we look at them as governance principles, not just principles for the regulation of AI. And I think that's an interesting question. Let's think. I think what a lot of these principles are rightly trying to do is ensure we have a trustworthy system. And a very laudable objective. We do not have the advancing of trust in the administration of justice as a principle in its own right. Do we need to spell that out? Would it help to spell that out, for example? So maybe once we start to take the governance perspective, what are the best principles may start to take on slightly different lens. And my last point, very, very quickly, is I think if we're talking and thinking about governance as well, we also need to be thinking about the need and opportunity for a data-led approach to monitoring and evaluation of what courts are doing, not just in this space, but more generally. So I don't think you can just look at AI in isolation in that way. And again, historically, this is something courts have not traditionally been good at. They've not been good at gathering data, they've not been good at using data in very, very sophisticated ways. And I think the more we move into the space of use of AI, ODR, these other new technologies, the more important it is that we do that.
Thanks, Julian. And thank you, everybody. Now we're going to go a little bit deeper, a little bit more precise now before we turn over to the audience. And I hope my panel will forgive me for pushing their views a little bit, and the audience will bear with me, because I'm going to ask slightly more pointed questions now. My background is a consumer lawyer, so now I'm going to ask some questions from the perspective of a consumer law complainant. So I'm going to start actually with Claire. Claire, I'm an unrepresented litigant, a small claim. My fridge isn't working. I need my fridge to work to feed my family. I know I can go to VCAT because the provider of the fridge won't give me a remedy. I don't know how to act in VCAT, so I go to good old chatty GPT and I say, how do I bring a claim? And it gives me pages and pages of things I can bring to court. I go to VCAT, I go with this claim. Is that a problem?
That's an interesting scenario, and one that's been talked about quite a lot. There was a conference for judges held earlier in the year in relation to AI, and similar to that proposition that was put to you, or that you just put to me, was a proposition that what if someone drafted an affidavit using ChatGPT? And I'll tell you a bit about the conversation around that because it's, I think, quite relevant to the question that you've asked. So that was put in the context of evidence and what is, how is evidence regulated and how could AI be used in the production of evidence. And the scenarios sort of thrown up in that questioning were, well, what's the difference between a self-represented litigant or party asking ChatGPT or Claude or one of those, even one of the legal ones, Lexis plus AI or one of the Thomson Reuters ones, to draft an affidavit or a submission in your case based on information they put into it, versus someone who maybe has a different economic status, who maybe has access to their own private solicitor, giving that same information to a solicitor and having assistance in drafting their affidavit. So there was a few scenarios thrown up around that, and the question that came out of it was one of our access to justice, the fairness in access to justice, and those concepts of accessibility. And I thought it raised a really good scenario to consider, because if we consider AI as a tool, then is it the responsibility of the person using the tool to put in the right data and then check the outputs is exactly what they intended to say. Now, in the affidavit example, that's different because you could provide some information and then have it spit out a more professional sounding statement about what you'd like to say, and you could check that and say, oh yes, that's what I meant to say, in a better tone. Maybe what the example you're giving about submissions, it could go searching for case law, for example, that could be hallucinated, cases that don't exist. I mean, there's a few famous examples of people doing that, professionals doing that in the courts around the world. So the risk profile, I think, is different depending on the use that you're taking, but also the consideration of accessibility and the use of it as a tool. Maybe we could think about how, in my case in engineering, it used to be that we did all our calculations numerically by hand, and then the advent of Excel spreadsheets came along, and now sometimes those spreadsheets get it wrong because people put the wrong information in, or it's been corrupted, the file's been corrupted somewhere along the line. So once again, that tool can be used, but it needs human oversight and it needs monitoring, coming back to these principles. So it's certainly a topical conversation at the moment.
It is, and I'll add two more points, which are that in VCAT, I don't think you're bound by a system of precedent. So I get some case law wrong, probably does still matter. And the other one is that, just for the audience, that it's cited in the paper, Matthew Dahl did some work on the accuracy of ChatGPT and then some of the legal tools. And ChatGPT hallucinated 60% of the time on American legal questions, then tried some of the legal tools and they hallucinated about 40% of the time on legal questions. So the risk is a real one. So as a litigant, I reckon that ChatGPT is not really doing me a good deal. So I go to Emma, who's a barrister. And Emma, I say, I need you to take on my case because actually, not only does my fridge not work, but it's blown all the electricity in my house. And I really need some help here. And Emma, you go, right, well, we get in hearing and we eventually get to court 10 years later. And we find out we're going before a particular judge. And my kids have grown up now, and my daughter, she's here, says, I've developed this really good predictive tool. What I've done, my daughter says, is I've taken all the judgments from the judge we're going before and run them through machine learning algorithm, and we've predicted how likely the judge you're going before is likely to decide the case. Emma, is that ethical or appropriate?
Well, it's the challenging thing, isn't it, about the capacity to review? Because it's, to your point exactly, it's kind of fine for me to review something generated by ChatGPT about the application of, say, Section 19 of the Civil Procedure Act, because I've done 4 cases in it, and I know instantly what's accurate, what's not, how to check it. One of the inherent complexities about, not so much in the VCAT space, but in the common law system, is the law could have changed 2 hours ago. In a civil law system, you've got the rule, you can, I can imagine it, this is the criteria I've got to meet, I'm going to draft something that fills those criteria. It could be that one of those criteria is critical because of something that's handed down in the court yesterday morning. My whole job is to make sure, I always say if any barrister ever tells you the answer off the cuff, they've got the wrong answer because they should be checking. This is not controversial. The problem is how credible it sounds. That's for me the real danger of all these tools. We did a joke thing for the Victorian Bar News, I think it's publicly available, but we did a test of are you smarter than an AI? And we asked you questions, posed the questions, and we flipped a couple of pages later and found out what you saw the ChatGPT answer. And then see if you could identify where the errors are, and then flip a couple of pages and check it. And we've got 2 of my smartest friends to double check it. But the problem is that if you don't know, if you don't have a
Emma, I'm going to ask you though, if you don't know, but if you're not in court at all, isn't 70% better than not at all?
Well, no. Because the problem of how judges are required, the transparency question, they're required to articulate their reasons. They're required to trace the logic through. They're required to take the text of the legislation or the rule as it's expressed in a case and then test it against the evidence.
Emma, I'm appearing, my claim is under the Consumer Guarantee Law and under the Consumer Guarantees in the Australian Consumer Law, which says if it's a serious failure, I should get damages.
Yes.
There's 4 cases on it.
And so, sorry, the question was?
The question was, sometimes the law is not that complicated, but I've actually said to you, I'm using a machine learning model to predict what the judge is going to decide. What about, I'll take your point about checking, what about using machine learning to predict outcomes in cases?
Yeah, so, I mean, inherently, if you can check it, if you have the skill set to be able to check it, then there's nothing wrong about taking it as an input. It's a consideration. The problem is relying on it. The problem is an unfiltered, the core value, the core principle of human oversight is the important thing here. And I guess in the 2 hours ago example is, and I have lived experience of this, you can have a very clear idea about very clear law, and it could have had a Court of Appeal judgment yesterday where the law is no longer clear. And
indeed, there was a High Court judgment a week ago on damages in the Australian Consumer Law, which actually changed what most of us thought. Thank you, Justice Edelman. Beautiful judgment, obviously. So, quite, thank you. And, okay, I'm going to turn to Kim now. Kim, you're our judge. Congratulations. Reported to the Supreme Court of New South Wales. And you now have a question. You've heard Justice Alsop, who said that judging involves intuition, judgment, and these are things that can't be replicated by an AI, but you're in a hurry. You've got a really long case list behind you, and you've got a lot of legislation. Can you use generative AI to summarise that legislation for you in a really hard and complex tax case?
Gee, I'd hesitate. And for precisely the reasons that you just outlined, right? Which is that at this stage of the technology, if I am, the technology has real challenges producing accurate answers on the law, right? So you've got, if it's going to be a 60% failure rate or a 40% failure rate, depending on the tool that you're using, I would be hesitating even for the summary stage. But I think we need to go back to that, when am I using this? How am I using this? At what stage in the process am I using this? Because if I am a judge with a heavy workload and I've got loads of cases behind me that, will need to be decided, but I am using a tool of this kind in order to get across what the law might be and what this case might be about, and going through some of these documents before a hearing to work out what questions I might want to ask counsel, or parts of the submissions that have been made that I might want to pick apart. That is different from using those tools to kind of summarise in a way that is leading much more directly to a decision. It's the really big concerns, and I think the consultation paper does quite a good job of highlighting this. The really big concerns
consultation paper's just got an H1, I think.
You told me I was a judge, not a professor.
Sorry.
But the really controversial stuff is if you are using it for the judging process, right? The decision-making process. And the reality is if you are using it after the fact, after a hearing to summarise some law, your risk of getting it wrong is problematic.
We've heard that Emma, Poole, KC, AO, would not have used generative AI because she would check her work. Mm-hmm. Would you ask her? Do you want to know if she's used it?
Do I want disclosure of the use of AI? Well, it's interesting, isn't it? I think, again, at this stage of the technology, what we are frequently asking for in the rules is disclosure. Tell us what you've done. Tell us how you've used AI. as a rule, I am not usually focused just on disclosure unless it's for a reason. It's like, what am I planning to do with that information? You know, if I suppose there are certain kinds of disclosure you might want because it might reveal something unethical. But if it's just, did you use it in research? Okay, and I say yes, and then you say, okay, but what am I doing with that information? I don't know. Like I think we have to think beyond just disclosure to what are we going to learn from it? What do we want to do with it?
Claire, did you want to say something there? That was, I
I
think,
can
your
see
point
what
earlier.
you're
Hot potato. There we go.
And then Julian, I'm going to ask you a short question, and then we're going to go to questions. So, Claire, I know you have a view on this one.
I think I've got 2 points that I wanted to make, and one was going back to the original question of should the judge use AI, or would the judge feel comfortable using it? Does a decision maker should they use AI? And I think there are some tools out there already. There's one in Canada and a few other international examples where there are tools that can be used, going back to the concept of before and after hearings again, tools that can be used before a hearing as decision indicators. So primarily I've seen the examples in sort of taxation law and things that are a bit more, I hesitate to say in front of other lawyers, a bit cut and dry or black and white.
Well, I think you'll find tax law is very rich, but
things that can be lend themselves more easily to an algorithm or assessing large amounts of data and yes/no tick boxes. And you could see that as a tool, and a lot of law firms are talking about using that as a tool to give their clients indication of whether or not they can take on their case, which, as anyone would say, a good barrister or a good solicitor would do with an informed approach and be able to ask the right questions and check the right things. But the question then arises of if you are using decision indicators either before or after a hearing in these hypothetical scenarios, what is the bias that you're basing your decision indicator tool on? So is there a historical bias in relation to the judge's gender or ethnicity or any of those things that may have created a bias in their decisions or in a trend in decisions that we then are embedding by using AI to do those decision indicators. So that was my
thank you.
first point. But the disclosure point is an interesting one because if I were to if I think about the scenario of asking someone to disclose if they've used AI, to your point of what is the point of that, you would want to go down the rabbit hole of what was the input in that tool, what was the output in that tool. And in expert evidence right now, in, for example, complex numerical modelling for flood modelling, we don't ask the expert to bring in their laptop with the numerical model on it and ask them to run it in front of us for however long it takes to run that model. But we do ask them to provide the inputs and the outputs in their technical report, and we verify whether they seem like reasonable results. And we have experts that do that in the judiciary and decision-making roles. So the question of why are you asking them to disclose and what do you do with that information and how far can you take it, kind of leads back to the original point of should they be using it. Because if you can't explain what has taken place in that tool, should you be using it? So that's a question that I think a lot of criminal evidence cases will be considering in terms of the evidence that comes before those courts, really specifically. Yeah.
Questions? Okay, Julian. Now, Julian, you're now the Attorney General. Congratulations. And my daughter has developed another tool. So she was quite inspired by Compass, which is the US recidivism prediction tool. But she decided she might point that in a different direction. So she's developed a tool that can predict tax fraud in plaintiffs. Will you authorise the use of that tool? Is that governance or regulation?
We haven't rehearsed this yet. That's a humdinger.
You can say pass if you wish.
I won't quite pass.
Thank you. I thought you'd be up to it.
Just judge whether I actually get anywhere close to answering it.
In 3 minutes,
Oh, in
please.
3 minutes, okay, I'll be very, very quick. My kind of dodgy answer to it is this is what we've all been angling around. So maybe this is kind of a way of bringing something to the conversation together rather than necessarily answering that one per se. Is the risk question. What kind of risks are we engaging with in the use of this particular kind of technology? And this is where I think the question of technology neutrality becomes kind of interesting, maybe kind of problematic, because I'm not actually convinced that any technology is ever really neutral in a deeply meaningful sense, but that gets us into some fairly heavy philosophy if you want me to sit back and justify that. So it's going to have effects. Are those effects of form or substance? That's quite a useful distinction for some purposes. It breaks down a bit, I think, in quite a lot of the legal conversations, and particularly in areas like evidence, where we could actually, the courts in some ways put quite a lot of reliance on form as well as substance. How something is said, how something is presented in documents, not just what is actually being presented. So we've got some real complexities here that this conversation has been drawing out. The tax analysis one takes us up another level because we're thinking of, I guess you're trying to ask me the question about the relationship between these sorts of tools and the kind of, if you like, the greater social good. How do we justify?
Thank you for thinking I'm so profound.
You are, Jeannie, you are. And I mean, we could perhaps tie that one back to, well, how does it sit with the principles that we started with up here? Does it advance any of those? That particular one. How are you thinking it might be used in the system, Julian?
I'm thinking that it takes data about the background demographics of the person who's before the court and makes a prediction about the likelihood of them to become engaged in tax fraud, which is the compass recidivism tool applied in
Yes.
Yes, for prosecution purposes. So it's one step up from, the barrister using the...
Yeah, no, that still makes me fundamentally uncomfortable.
Doesn't fit within these. I'm going to give... Emma, I think, wants to say a thing, and then I'm going to turn it over to the audience. Did you have a comment on that, Emma, or say... Okay. Right. We've run out of my provocative questions, and we're turning it over to the audience now. We're taking questions for our fabulous panel.